provisions of the Safe Drinking Water Act.
And the CFR, I mean, and the enabling regulation.
Right, that's the CFR 146.4, yes.
Okay, all right.
Has the department ever produced or promulgated or worked on regulations to update the cyclic steam? Is there anything in the works?
We have actually, there is a committee that's called the California Conservation Committee for Oil and Gas Producers, and it was formed quite some time ago to allow operators to get together without antitrust concerns. So it's in statute in California. We have relied a great deal on the expertise of the CCC OGP to look at the issue specifically of cyclic steaming and shallow diatomite formations. And that was particularly after the death of Mr. Taylor. And we were quite urgent about getting the operators together because the diatomite formations that are being produced right now are extremely different from one another. Santa Maria and Orcutt Hill, a very different anticline or incline to the formation versus South Bell Ridge or in Lost Hills. So there are so many different ways to apply the technology that we really do need to work with the operators to figure out what are the proper ways to limit deformation, surface expressions, et cetera.
Gentlemen, thank you for your testimony this morning. I will excuse you now. Thank you for the information you're going to be providing to the committees. Oh, I'm sorry, Senator Hill?
Yeah.
Senator Stone.
That's okay. Thank you. I appreciate being able to participate. Gentlemen, thank you for your testimony. Just a few questions. It's my understanding that a lot of the geological data is antiquated, 35 years old, and over time more geological data is being known, but the original map boundaries are not up to date. So what is the process that we're going to be looking at, real geological boundaries when we're looking at aquifers and areas in which gas production, oil production can happen? And second question, you talk about granting exemptions and not granting exemptions, and one of the exemptions is that if there's hydrocarbon in the water, if the total dissolved solids or the salinity of the water is high, but you may not grant an exemption if it's economically treatable, that water, to be used for potable reasons, agriculture. So number one, how do we deal with the antiquated maps and making sure we have the appropriate information to make our decisions? And two, with regard to the exemptions and non-exemptions, how are you defining what is economically treatable?
So I'll leave the second one to Jonathan. But as to the first, part of the data challenges that the division has is that it does not have modern data management techniques. It has GIS, Geographical Information Systems capabilities. They're not as robust as they need be by a long shot. But to your point, some of the challenge that we currently have is the result of oil and gas industry expanding out of the 1973 boundaries of the productive limits by virtue of the fact that new techniques or capabilities have made zones which might have been uneconomic for oil recovery economic, and that's fundamentally why we're in part of the reason we're in the problem that we're in. Right. As part of the aquifer exemption process to basically get back into compliance with Safe Drinking Water Act, which is another way of saying of redrawing the boundaries of the productive limits of the field, if you want to look at it that way, we will be requesting the appropriate geologic information from the operators and asking them to provide us with all of the data that we need in order to do the things you're talking about, which is through aquifer exemptions that are granted, redraw the productive limits of the fields. So
you're going to be taking this on a case-by-case basis. You're not.
That's correct.
There's no study out there examining 50,000 wells in the state of California.
No. Well, in fact, the operators have the information about both where they obviously are now or where they want to go, and they have the opportunity to provide us with those data. And some operators are cooperating to the extent that they can with antitrust issues coming into play, so that we may look at large portions of an entire field that may be expanding outward or could expand outward. And then the criteria, the geologic criteria that they provide would become part of the division's analysis in order to make a decision as the part of the division as to whether this is appropriate, economically recoverable oil deposits, et cetera, et cetera. And then, of course, then the water board would make its own determination with respect to your second part of your question.
Okay, so forgive me one second. So the operator is going to be required to do the geological studies.
Yes, that's correct.
And so with all transparency taken into consideration, how do we avoid the stigma, if you will, that the fox is guarding the hen house? Who's reviewing those geological studies to ensure that they accurately and positively represent the potential impacts to the oil acquisition that's contemplated?
Right. Well, there's a wide variety of data that go into the analysis. So the division will be analyzing those data. But there's certain things that you have to have there. You have to have evidence of economically recoverable oil. So exploratory wells, which wouldn't be governed by the UIC program because they're not injection wells, but they would be evidence of the volumes of oil that one could expect to produce if that zone were allowed to produce using enhanced recovery techniques, for example, that would bring it into the realm of the underground injection control program. So it's not so much a conjecture about the geology, which I think gets to your issue that, well, they could fool us. It's actually hard evidence of, well, here are cores of exploratory wells. Here are zones of oil. We know the oil saturation. We know the kind of oil that's there. We know there's a lot that an oil and gas reservoir engineer, of which we have those, can tell from exploratory wells about the viability of a formation to be economically capable of producing economically oil.
So you believe you have the staff that has the professional capabilities to oversee these plans and projections?
We can discuss whether we have a sufficient number of staff, but we do have staff with the technical capability to make those kinds of assessments and judgments, yes.
Thank you.
Mr. Bishop.
Yes, so your question was how would we determine if it's economically feasible to use the water? And that's is a very site-specific per project evaluation, because you're going to have to look at the depth and location of the aquifer. There is a point, and that point changes depending on how available water is and where you are in the state, where it's no longer economical to drill that deep. And there's a point where the cost of treatment is too high because there are other sources that are accessible that are less expensive. So you have to look at where you are. We're in the 4th year of a drought. Water is a lot more precious than it was 4 years ago. And the cost of treatment is a lot more palatable now than it was 4 years ago. We'll be looking at the potential, not that there's someone actually doing it today, but that it is viable to do that. I know that recently I had a gentleman come to talk to me about he wanted to buy production water, treat it with RO, and sell it to the farmers because he had identified farmers that would pay enough that he could make a profit on that. So that's a pretty high bar there that we're looking at for potential for water use. So it's really going to be location more than treatment cost.
I appreciate that. And then just lastly, Senator Allen brought out the issue of public review and checks and balances. I'm very pleased to see that the two agencies are communicating and the public has a third bite at the apple, if you will. Thank you for your testimony today.
Thank you, gentlemen. Thank you.
And that will close this portion of our hearing. Thank you once again, gentlemen, for your time. Now let's move to the California Environmental Protection Agency's review of the underground injection control program. And I want to thank Secretary Matthew Rodriguez, who's been here for 2+ hours, who's the Secretary of the California Environmental Protection Agency. It's still good morning, Secretary. Welcome to our joint hearing.
Good morning. Thank you for having me here today. In view of the hour, let me just be brief and give you an opportunity to ask me some questions. I think we covered our review of the underground injection well program in the brief memo that was provided and that I understand you all have. And let me add that memo was actually, even though my name is attached to it, was prepared by a very, very good attorney on the Cal EPA staff, Nicholas Haydorn, who did an excellent job in looking into this situation. The charge that was given to Cal EPA was to figure out what happened. How is it that it appeared that injection wells had been allowed into aquifers that had not properly been exempted? In brief, there are two categories, I think you would say, where we found that there were problems. The first category had to do with the fact that when the state initially asked for an exemption as part of its application to take over this drinking water program, it specified that it would ask for an exemption for aquifers as defined by their 73 or 1974 production limits. Over time, that restriction that restricted the exemption to the 73 or 74 production limits was lost to the staff at Dogger. So what we found was that there were situations where wells were allowed in areas that were currently under production, but the production areas for some of these hydrocarbon producing areas had expanded because of new technology. They were beyond what was the 73 and 74 limit, and that was not taken into account. Additionally, we found situations where the aquifer would be defined in 3 dimensions. It had not only a surface description, but it also had depth. But staff was not looking at that depth, and so they were allowing injection wells to go outside of the aquifer, to, for example, below the aquifer depth that was identified. Additionally, there was a situation where an aquifer would be identified not by its production limits in 73 or 74, but it would be identified by a certain administrative boundary. And so a well would be allowed into an aquifer or into an area that was identified by its administrative boundary. But again, that administrative boundary, which was really based on surveys and how the state is divided up into sections, didn't reflect the 1973 and the 1974 production limits. And so there was that classification where it was just not enough attention was paid to that qualification in the state's request for exemption. That's the one category, and that covers about half of the wells that we're dealing with here. The other category of problems really went back to the fact that the state applied for exemptions for a number of aquifers in its application for primacy, and it identified a number of aquifers where there was existing ongoing oil production. EPA, US EPA, in response to that, initially denied an exemption for 11 of those aquifers. And an agreement signed in September of 1981 said that those 11 aquifers were not exempt. And it went further to say that because this area was in production, that injection wells in those areas had to be removed within 18 months after this agreement became final. Now, it's important to note that this agreement between the state and the federal government wouldn't be final until it was approved by the EPA administrator. When that agreement was submitted to US EPA, US EPA wrote back and said they had some concerns about this requirement that the injection wells be removed within 18 months. And additionally, a new copy of the listed exempt wells was provided that included as exempt the 11 aquifers that had been previously deemed non-exempt in the initial agreement with Region 9 EPA. There is then, as we find in looking at the record, and it is always, of course, difficult to go back and recreate a record from 30 years ago, but what we find is that there was then a submittal to the regional administrator in sometime in December of 1982, and our understanding is that it probably included that revised list of exempt aquifers. And then there was just a statement that by the regional administrator in March of 1983, and there was a notice in the Federal Register saying that California's application had been approved. All of this is complicated by the fact that all that was really changed between the 1982 submittal and agreement between the state and EPA and what went to the administrator later was that they had just changed that list of exempt aquifers, but they'd kept all the other documentation the same. And so we were still dealing, so if somebody referred to the agreement with a date of September 1982, that covered both the original version as of September and then the subsequent changed version. Now there's some confusion, and I use that word lightly, but there's some confusion thereafter because there is a discussion in some DOGGR documents about appeals of a denial of an exemption. And that seems to have given rise, then there's documentation that suggests that those appeals had been granted. And then in 1984, we're aware that the US EPA acknowledges there's some confusion about what's exempt and what's not exempt. And in 1985, US EPA provides a list of exempt aquifers in response to the oil industry, and it included as exempt those 11 disputed aquifers. And that really then became accepted both at US EPA and at DOGGR for a long period of time as the list of exempt aquifers. What happens is then in 2011, it's noted that by a staffer at DOGGR that there seem to be these conflicting lists of exempt aquifers. In 2012, this is discussed with US EPA, and the decision was made at that time that they should go back to the original list of exempt aquifers, and so remove those 11 aquifers that were being considered as exempt, no longer consider them as exempt. And that really reflects where we are today. They're not being considered as exempt, and in fact, if you want to put an injection well, as you heard into this morning's testimony, you have to get a specific exemption for your wells as you go ahead. But that's our understanding of the progress in all of this and how we arrived at our present situation. So as I said, I tried to be brief. If I've been too brief, by all means, let me know. But I just wanted to cover that that's how we arrived at the situation that we're in today.
Do you feel like Cal EPA is able to do proper oversight of the UIC program, given the statutes that exist right now? I mean, I understand, I see how we had this little problem, I'll call it problem, confusion.
Well, let me say that one of the reasons why we were chosen at Cal EPA to look into this matter is because we don't have any direct role in the UIC program at this time, other than the fact that the State Water Resources Control Board is within Cal EPA. On the other hand, we have an interest in making the programs of the state of California work, and we want to protect the drinking water resources for the state of California. I think it's just a question of making people comply with the law and making sure that the staff is aware of the standards that should be used as we look at our permitting decisions. I think that we're committed to making the existing laws work, and I think if we comply with those laws, we should be protecting the interests of the citizens of the state of California.
All right, we're here by ourselves. Thank you. I don't have any more questions prepared, so I will thank you for your testimony and excuse you and open up the public comment period.
Okay. Thank you very much.
Our staffs will be in touch.
Okay, thank you.
Now we'd like to hear from the public. If anybody would like to address the joint committees, we have a microphone here to my left. Please come and identify yourself. If you're with an agency or you're with a group, please identify them. And yeah, if you have a written statement, you can please submit that, and that will become part of our record.
I'm Bill Alio with the Environmental Working Group. Been working on this issue for about 4 years, started with now Senator Wachowski trying to get fracking regulated. Where to start? I think the culture of Dogger is a problem. For 100 years, this is their 100-year anniversary, they've basically been in bed with industry, giving them what they want, rubber stamping permits. For example, ignoring the Permit Streamlining Act that all state agencies, local and state agencies have to comply with. Tim Kustick, the supervisor, told me he never heard of it. They say that their bread and butter is well casing standards and pressure tests are all over that. They then admit that they don't observe many well pressure tests at all. They can't tell us where any well casings have failed. They have no database. In 2009, they got new management who came to the legislature and said, we want money to quote an expansion of the existing regulations that are needed to clearly outline the regulatory framework over all injection wells under Dogger's current authority. This includes shallow thermal diatomite injection wells, hydraulic fracturing, steam injection, and CO2 ERR injection wells. Got the money, never did it. Then what's new to me is this memo from 2010 published for this hearing from then Supervisor Elena Miller to the staff of Dogger saying, basically, you got to follow our own rules and regulations. And that was the problem, and they got fired, she and Derek Chernow, for their trouble for saying we're ignoring CEQA, we're ignoring our own rules and regulations. They get fired. So what happened next was the fracking thing came up. And so now Dogger's saying, look, we were so busy doing fracking, we never got around to preparing new well casing standards, new UIC regulations. Well, I think this agency can walk and chew gum at the same time. So now we're behind, and now we're all looking at the UIC going, what's going on there? They prepared a roadmap. They didn't do the things they'd say in that except for hydraulic fracturing regs. And the picture the industry's painted of Kern County is that this is a desert with poor groundwater, saline water, and not to worry about a thing. And the recent revelations about injection into good water to decent water is shocking. As far as being overregulated, I think the entity, and especially Kern County, has been underregulated by both Dogger, the Water Board, and the Air Board, where they have open pits with volatile organic compounds going into the air of one of the most polluted places in the country, where we now find out the underground injection control program wasn't being adequately overseen. Benzene is present in all these waters, and as Mr. Bishop said from the Water Board, it's really hard to clean this stuff up. I gather from what he said is that there are no problems in that people's water wells are not pulling these chemicals up. That's, I guess, the silver lining in this. But the aquifer next to them is polluted and admittedly very hard to clean up. So I don't know why we're still allowing injecting into these wells, into these waters. Good or bad, 10,000 TDS or whatever. It's outrageous. I do think the new management at Dogger sees the cultural problem there and wants to do something about it. So will they, and will we really get going on this and have them not have a law that says permits are deemed approved within 10 days if they don't act, and ignoring the Permit Streamlining Act, and still saying industry can use any methods known to them to get hydrocarbons out. I think this whole thing has to be flipped to say that they shall get permits to do these things if they pass muster. And in the Elena Miller memo from 2010, it said staff shall put everything into writing when they approve one of these UIC permits. I'd like to know if that's happened. I doubt it, and things are just rubber stamped over there for too many years in a row. We're finally catching up. Thank you.
Thanks.
Thank you. My name is Andrew Grinberg. I'm the Oil and Gas Program Manager with Clean Water Action. I'd just like to focus in on one very narrow piece of this whole debate, which is the fact that the state is knowingly allowing 2,500 injection wells to remain open in direct violation of the Federal Safe Drinking Water Act. And it's completely unacceptable to willfully violate federal law aimed at protecting our current and future sources of drinking water. Are we going to look back in 5, 10, 50, 100 years and think, wow, we wrote off those aquifers for we made the determination that oil and gas being able to dump their waste was a preferable use of those underground formations. Yet here we are, 2015, in the midst of an extreme drought, and we know that there are injections going on into these aquifers which do not have, the federal determinations made that they're suitable for injection, yet we're allowing them to continue to operate. And that has not been answered. And the public has really latched onto that. And I think that when you've got a state agency that's knowingly not enforcing federal law, you're going to lose a lot of confidence. And that's, when we talk to our members, and I know a lot of organizations have a very outraged member base right now. And one example, Clean Water Action, along with CLCV, EWG, and Community Water Center, a couple other EJ groups, in about a week, collected over 22,000 petition signatures calling for the immediate shutdown of these wells. We've delivered these to the governor's office, and we've notified Supervisor Bolin and Mr. Nekadam. And what we're seeing is really the public is not going to stand up and allow oil industry profits to be put ahead of potential drinking water sources when we see how scarce they are here in California. So we're still searching for answers as to why these wells remain open. And like I said, this is just one narrow piece in this whole mess. And there's a lot of things that the legislature can do to step up and make sure this doesn't happen going forward. And we're looking forward to being really engaged this legislative session to make sure this step of mistakes don't happen again. Thank you.
Thank you. Next.
Good morning, Chair Wachowski and members of the committee. My name is Holland Krutzman with the Center for Biological Diversity. I'd like to first commend the committee staff for putting together very useful background materials for this hearing. I believe they highlight Dogger's systemic failures to protect our groundwater here in California from oil industry pollution. Even as we speak here today, hundreds of illegal waste disposal wells are dumping toxic oil industry wastewater into our protected aquifers. This is material that contains benzene and other dangerous chemicals. And we've also discovered recently that dangerous high-pressure steam injection is occurring throughout our state's oil fields while Dogger rubber stamps new permits every week. It's only common sense that in a crisis like this, the first step is to stop ongoing damage immediately. But despite admitting massive noncompliance with laws meant to protect Californians, Dogger plans to allow illegal injection to continue for months and in some cases even years. We've heard attempts today to characterize this as a communication issue, that it's an administrative snafu. We've heard misleading comments about how there's no water contamination. That's simply not the case. Everyone agrees that there are harmful chemicals in oil industry wastewater and that these chemicals have been put in protected aquifers. That is beyond dispute. It's a disturbing refusal to acknowledge the magnitude of the problem and the many serious legal violations made along the way. That kind of denial underscores the fact that our state oil agency is simply not up to the task of protecting our groundwater. After years of pressure from the federal EPA, Dogger has finally admitted that hundreds of injection wells are allowed to dump this industry waste into water that should have been protected. It's inexplicable that Dogger is allowing these injection wells to continue operating even after it became clear that they are violating the law and injecting dangerous wastewater into aquifers that are supposed to be protected under the Safe Drinking Water Act. Dogger has shut down to date just 23 of the wells that are operating illegally, dumping billions of gallons of waste fluid into protected water. There are also thousands of production wells operating in aquifers that should be protected. All of these wells must be shut down immediately. It is not up to Dogger to decide when it must comply with the law. It is troubling that Dogger is patting itself on the back for coming up with a plan. The problem is that plan is illegal. It does not comply with the Federal Safe Drinking Water Act. The time to comply is not 2 years from now or even months from now. You have to comply immediately. Dogger has long known that the fluid injected into these disposal wells is toxic. A 1993 study, Dogger's own study, showed that there were high levels of benzene contained in the produced water that came from some oil industry produced water samples. The highest of those tests found 18,000 parts per billion of benzene. In comparison, the EPA limit for safe drinking water is 5 parts per billion. More recently, oil companies' own tests have found high levels of benzene and other BTEX chemicals in fracking flowback fluid. Benzene, on average, was detected in fracking flowback at 700 times the EPA limit. Almost all this fluid and much of the produced water is put into disposal wells, as we now know. And now it has been revealed about a third of our state's disposal wells have been operating illegally, injecting into protected aquifers. This must stop immediately. Yet Dogger has not even guaranteed that these illegal wells will be shut down at all. Instead of spending its resources on immediately shutting down illegal wastewater dumping, Dogger is running workshops to help the oil industry apply for new aquifer exemptions. This is a perverse use of the Safe Drinking Water Act and a complete dereliction of Dogger's duty to protect our natural resources. Another critical problem is the lack of oversight over steam injection, or cyclic steaming. The oil industry in California routinely injects steam at pressures high enough to fracture the formation below. Using such high pressures in an injection well is clearly prohibited by the state's UIC program and federal regulations. The widespread use of high-pressure steam injection is not only a threat to our groundwater, but also a safety menace. Steam injection at pressures above fracture gradient has led to land subsidence and sinkholes. And in 2011, an oil field engineer, Mr. David Taylor, fell into one of these sinkholes and tragically died. Now we've learned that this illegal technique that creates these dangerous sinkholes is routinely approved by Dogger for use in our state's oil fields. Dogger's failure to stop these illegal activities, especially after such a tragic fatality, is another disturbing example of the agency's unwillingness to protect the public from the oil industry's dangerous activities. We cannot wait years while the agency promises to reform. We've heard it all before, past promises for rulemakings, staff and budget increases. These have all failed to curb illegal and dangerous activities. The legislature should make clear to Dogger that it expects our laws to be followed both by the agency and by the industry. All injection wells operating in protected aquifers must be shut down immediately, and to comply with Dogger's own regulations, illegal high-pressure steam injection must stop as well. These laws are meant to protect our water and our health. They need to be obeyed starting now. Thank you very much.